Hello, everybody. For those of you I don't know, I'm Bob Levy, Chairman Emeritus of the Cato Institute, a libertarian think tank in Washington, D.C. When I refer to libertarian, I don't mean the political party. I mean libertarianism as a political philosophy of personal and economic freedom. Libertarians believe we should be able to live our lives as we choose, as long as we don't interfere with other people who may wish to do the same. Libertarians are not conservatives, although many of our views are congruent with the views of conservatives. We do have a consistent, minimalist view of the proper role of government. We want government out of our wallets, out of our bedrooms, and out of foreign entanglements, unless America's vital interests are at stake. Those positions are loosely defined as socially liberal and fiscally conservative. But the key ingredient is a principled consistency regarding the role of government, which is limited to safeguarding individual liberty. Today's topic is federalism, with a focus on one particular application, the sanctuary city movement. First, I'm going to set the constitutional framework for deciding who rules, the feds or the states. That framework includes the 10th Amendment, which limits the power of the federal government, the 14th Amendment, which expands the power of the federal government, and the Supremacy Clause, which tells us what happens when federal and state laws disagree. Then I'll review a few related questions that are key to understanding the balance of power, whether states can nullify federal law, whether states have to enforce federal law, and whether the feds can get the states to cooperate by granting or withholding federal benefits. And finally, I'll examine how those issues help us understand the current controversy over sanctuary cities. We'll begin with the basics in the question and answer format that I've used in other talks. That's where I pose the questions and then I provide my own answers. So let's get started with question number one. What is federalism? Is it synonymous with states' rights? Answer, no, it's not just states' rights. Federalism refers to the division of power between federal and state governments. And to flesh that out, here's an intriguing 2011 Supreme Court case called Bond versus United States. Carol Bond's husband impregnated Carol's best friend. Carol was understandably vexed, and so she spread toxic chemicals on her friend's car and mailbox, causing her friend minor burns. Of course, that's against the law in every state. Ordinarily, Bond would have been charged and tried by Pennsylvania where this occurred. Instead, she was charged under a federal statute that implemented the 1993 Chemical Weapons Convention. So it's not that the Obama administration was especially interested in Carol Bond or really believed she was involved in chemical warfare. What animated the president was an opportunity to expand federal authority even into state issues using the federal power to make treaties. Ms. Bond predictably challenged her indictment by claiming that her offense was a state crime, had nothing to do with the Chemical Weapons Treaty. But the Court of Appeals dismissed her suit. The court held that Bond was asserting states' rights, but since she wasn't a state, she had no standing to litigate. In an important but overlooked opinion, the Supreme Court rejected that logic 9-0. Justice Kennedy wrote that the 10th Amendment is not just about states' rights, it's about federalism, the purpose of which is to divide power between two sovereign authorities, not primarily to protect states, but to, quote, protect the liberty of all persons within a state. So, Ms. Bond did have standing to litigate, and in phase two of the case, she prevailed, again, 9-0. Chief Justice Roberts held that the treaty-based statute did not cover Bond's conduct, which was simple assault, and states prosecute assaults. The takeaway: federalism is not only states' rights, it's the division of power to safeguard individual liberty. And that leads to question two. What controls the relationship between the federal government on the one hand and state and local governments on the other? The most relevant constitutional provision is the 10th Amendment. It tells us that the national government can exercise only those powers enumerated in the Constitution. The power to coin money and declare war, for example. The powers not delegated and enumerated are reserved to the states, or depending on state law, directly to the people. Conservatives and libertarians generally agree on that tightly constrained view of federal powers, but there's a key exception. Many conservatives, but not libertarians, are willing to federalize a significant amount of criminal law and civil law. If you want an example in the criminal law area, consider our feckless war against drug use and possession, for which there is no constitutional authority. The text of the Constitution mentions just a few crimes: counterfeiting, treason, piracy. And yet, many conservatives have convinced themselves that the harm from drugs justifies ignoring our founding document. In the civil law area, there's tort reform. No doubt, tort reform is necessary and desirable, but there's a threshold concern. Where in the Constitution is it authorized? Advocates of federalism invoke this principle. No matter how worthwhile the goal, no matter how sure Congress is that it's identified a big problem and knows how to fix it, if there's no enumerated federal power, then the feds have to step aside, leave the matter to the states or to private parties. And it's not just tort reform. Today, the federal government immerses itself in matters ranging from our public schools to hurricane relief, retirement systems, welfare, family planning, housing, even aid to the arts, none of which can be found among Congress's enumerated powers. See if you can find anything in the Constitution authorizing federal aid to the arts. Maybe so, you might say, but how about this question, number three? Didn't the Civil War give the federal government a new set of powers? Yes. Until 1868, the Bill of Rights did not apply to the state governments. For example, the First Amendment says Congress shall make no law impairing free speech. It says nothing about states making such laws. But we discovered over 80 years that the states can every bit as tyrannical as the feds. Slavery and segregation were the obvious cases in point. And so we fought a civil war and we ratified a few post-war constitutional amendments, most importantly the 14th, which prevents the states from violating due process, equal protection, and the privileges or immunities of citizenship. The 14th Amendment was used to apply, the technical term is incorporate, the Bill of Rights to the states. Essentially, the 14th Amendment gave the feds a new power over and above the powers enumerated in the Constitution and referenced by the 10th Amendment. After 1868, if a state were to violate a right guaranteed under the federal Constitution, the feds, not only Congress, but also the executive and judicial branches, would be authorized to intervene. Question number four: what happens if a state enacts a law that conflicts with federal law? That's covered by the Supremacy Clause in Article 6 of the Constitution. It says that federal law is the supreme law of the land, no matter what state law says. The clause also provides that, quote, judges in every state shall be bound thereby. Interestingly, the Supremacy Clause refers to judges, but doesn't specifically mention state legislatures or governors. And consequently, that raises question number five. Can a state or local legislature nullify federal law? The answer is no. The theory of nullification holds that the federal government exists by the will of the states, and that states, therefore, have the right to decide which federal laws are constitutionally valid within their borders. But the U.S. Constitution, ratified by the states, has been interpreted to mean something quite different. Our courts have the final word. In Federalist 78, Hamilton wrote that courts have the duty, quote, to declare all acts contrary to the manifest tenor of the Constitution void. Madison shared that view. He said that states can declare federal laws unconstitutional, but the declaration would have no legal effect unless the courts agreed. In Madison's report of 1800, he wrote that state declarations are expressions of opinion, intended only for reflection. The expositions of the judiciary, on the other hand, are carried into immediate effect. And 3 years later, in 1803, Chief Justice John Marshall settled the matter in Marbury versus Madison. Marshall wrote, "It is emphatically the province and duty of the judicial department, that is, the courts, to say what the law is." And that doctrine has been followed ever since. Instead of 50 individual states and hundreds of localities reaching different conclusions regarding constitutionality, we have one Supreme Court establishing a uniform rule for the entire nation. Nullification advocates point to the Kentucky and Virginia resolutions of 1798 and 99, in which Jefferson and Madison asserted a state's rights to nullify the Alien and Sedition Act of 1798. Consider those resolutions in context. Jefferson and Madison argued that the states had the final word because the Constitution did not expressly give that job to the Supreme Court, and in any event, the court had not ruled that the act was unconstitutional. But, as I already noted, Chief Justice Marshall corrected that omission in Marbury versus Madison. The Supreme Court, exercising judicial review, has the final word. That's the law. So what happened to the Kentucky and Virginia resolutions? 7 states rejected them. 6 states passed alternate resolutions holding that constitutionality was for courts to decide. 4 states took no action. Not a single other state affirmed the Kentucky or Virginia resolutions. Fast forward to the Civil Rights era, 1956. Opponents of the Supreme Court's blockbuster desegregation decision, Brown versus Board of Education, declared that the schools could remain segregated despite that decision because it violated state sovereignty. The court responded in 1960, holding that, quote, nullification is not a constitutional doctrine. It is illegal defiance of constitutional authority. Imagine if states could nullify federal laws. Orville Faubus could have blocked Arkansas school integration. Virginia could have continued its ban on interracial marriages. Texas might still be jailing gay people for having consensual sex. Chicago's gun ban would still be in effect. So states cannot nullify federal law. But that's not the whole story. Question 6. Are states required to enforce federal law and to enact federal regulatory programs? The answer on both counts is no. In the 1997 case, Prince versus the United States, the Supreme Court ruled that the federal government could not commandeer state law enforcement authorities to conduct background checks on handgun purchasers. In the 1992 case, New York versus the United States, the court ruled that Congress cannot obligate the states to enact specified waste disposal regulations. So, to repeat, the feds can't compel the states to enforce federal law, and the feds can't mandate that the states enact a particular law. But suppose the states use a carrot and stick approach. Question number 7. Can the feds grant or deny benefits in order to encourage state cooperation? So instead of forcing the states, the feds sometimes make their programs optional, usually by promising the states they'll receive lots of money by cooperating, or they'll be denied benefits if they don't cooperate. That's called conditional spending, designed so Congress can achieve ends that might otherwise be constitutionally suspect. The key case was South Dakota versus Dole, 1987, in which the states were told to adopt a 21-year-old minimum drinking age or else lose 5% of their federal highway funds. Chief Justice Rehnquist said that was okay as long as the carrot or stick was closely related to the state's cooperation that the feds desired. In the Dole case, Rehnquist, amazingly from my perspective, concluded that the connection between highway funds and drinking age was close enough. Supposedly, teenagers drive to low-age states, have a few drinks, then drive home. And Congress wanted the roads that it finances to be used safely. So that's all it took to link driving age and highway funds. During the 24-year period after the Dole case, the court did not invalidate a single use of conditional spending. But then in 2011, a new condition was added with the Obamacare opinion. Chief Justice Roberts and 6 other justices held that the threat to withdraw all Medicaid reimbursements if a state refused to expand its Medicaid program was coercive. Practically, it left the states with no real option. So in effect, there's now another test for the carrot and stick policy. The funding may not be so vital to the states as to essentially force their compliance. Cooperation cannot be compelled, but question number 8, can a state or locality impede federal enforcement of a federal law? Again, the answer is no. Under the Supremacy Clause, the feds have unquestioned authority to enforce their own laws using their own law enforcement personnel. So individuals are not exempt from prosecution by the feds merely because they live in a state that considers the law unconstitutional. There is no express or implied power in the U.S. Constitution that allows states to prevent federal enforcement. Let me summarize. First, state officials need not enforce federal law. Second, Congress can't order states to enact specific laws. But third, states may not block federal officials from enforcing their own laws. And fourth, the feds can't tacitly compel state cooperation by granting or denying critical benefits. And now a real-world application of those principles. Question 9, how have the principles applied in the context of sanctuary cities and states? Roughly 200 jurisdictions, states and cities, have declared themselves to be sanctuaries for selected immigrants. Additionally, some states refuse to provide data to the feds for gun background checks. Dozens of states have legalized marijuana despite the Federal Controlled Substances Act, and a number of states have declined to expand the federal Medicaid program. As I just stated, federal law supersedes conflicting state law, and states may not impede federal enforcement, but neither the president nor Congress can commandeer state officials to enforce federal law. If the feds want their laws enforced and local jurisdictions refuse to cooperate, then federal enforcement personnel must be used. In the immigration cases, former President Trump threatened to cut funding for sanctuary jurisdictions. That threat was clearly incompatible with federalism. There must be a logical connection between any federal funding that's withheld and the goal of the law that the feds want enforced. Accordingly, if the feds want to punish a sanctuary city by withdrawing federal benefits, the monies withheld would have to be linked to federal immigration objectives, not, say, overall crime reduction. Federal appellate courts in Pennsylvania, and California have affirmed that principle. And lastly, the feds may not deny funding to states in a way that essentially compels their cooperation. Coercive conditions imposed on receipt of federal funds cannot be harmonized with federalism. We are a nation of laws with sovereignty split between the feds and the states. Officials in sanctuary cities cannot obstruct federal enforcement of federal immigration laws, but collaboration is not constitutionally mandated. The difficulty, of course, is distinguishing refusal to cooperate from active obstruction. Finally, just a few words regarding federalism's $64 question. Historically, many states discriminated against African Americans and allowed private businesses to operate segregated restaurants and hotels. The 1964 Civil Rights Act was crafted to address some of those problems. How can the 1964 Act be reconciled with principles of federalism? First, let's consider discrimination by the states themselves as contrasted with private businesses. As I related earlier, the ratification of the 14th Amendment in 1868 empowered the federal government to intervene whenever a state denied equal protection of the laws to its citizens. So there's little doubt that federal remedies to stop states from discriminating by race were constitutionally authorized and completely consistent with the notion that the feds and the states exercise dual sovereignty. On the other hand, the 14th Amendment is limited to curing state misconduct. Accordingly, the legitimacy of the Civil Rights Act as applied to private businesses raises difficult constitutional questions. In 1964, two Supreme Court cases upheld the Civil Rights Act. One involved the Heart of Atlanta Motel, which refused to house Black travelers. The other involved Ollie's Barbecue, which refused to feed Black travelers. The court held in both cases that the 64 Act was authorized as a regulation of interstate commerce. In my view, that holding was incorrect. The purpose of the Interstate Commerce Clause was to stop the states from interfering with free trade, not to give the federal government plenary power to regulate private businesses. A better argument, it seems to me, is that state actions, for example, Jim Crow laws, induced and facilitated discrimination against African Americans by private firms. That's what validated federal redress under the 14th Amendment. Private businesses that discriminated were aided and abetted by government collusion. The offending states used three strategies. First, they controlled the police and the courts. Second, they denied services such as water and electricity to firms that wouldn't toe the segregationist line. And third, they ignored or even supported private violence. So yes, state and federal anti-bias laws like the 1964 Civil Rights Act were justified to counteract government complicity in private racial discrimination. In any case, the Civil Rights Act, insofar as it was implemented to restore racial equity, helped erase an unconscionable assault on human dignity. It's now settled law, not to be revisited, despite questions related to its constitutional pedigree. That's my story. I'm sticking to it. And many thanks for your time and your attention.